Hello, my name is Dr. Kshitij Singh, and today I will be speaking on a topic that understanding your IP. IP means intellectual property. So, why it is important to understand your IP in the present knowledge economy? There are several reasons for that. I mean, every asset or every tool which we use in one way or another, there is some intellectual input in it, and because of that very input, it becomes more valuable rather than because of its physicality. So that is why we need to know and identify what are the potential aspects which could be protected through intellectual property. And intellectual property may also help monetizing that very process, that very aspect, and one can gain economic results over those resources, over those, you can say, assets. And in a way, it has a twofold objective. First one is to give a due to that very person who is entitled to it. So any person who is involved in intellectual activity must be rewarded with some incentives so that he may be encouraged to do something which is creative or inventive. On the other hand, it is also important to encourage these activities so that the economic progress could be ascertained, because the current economy is very much geared by these kind of levers. So coming to this general concept, intellectual property as compared to other property has some distinctions. So first of all, if we go by the term only, it is intellectual property. So the term property is qualified by the term intellectual, which simply means that the labor or the effort which is involved in creating the property is intellectual effort. May it be, any creative work, may it be inventive work, but all in all, it requires some intellectual input. And that property is valuable because of that very intellectual input. That is why it is termed as intellectual property. So in these days, I mean, intangible assets are gaining more importance as compared to tangible assets. May it be mobile phone, may it be any other stuff, may it be laptops, may it be high-end technologies. So that very effort which has been put in that very thing which we use has become more important because of that very intellectual effort. So we need to appreciate that, we need to protect that. So intangible property that is result of intellectual creativity could be said or could be termed as intellectual property. So the human intellectual activities that commonly result in most intellectual properties are either result of innovation or result of creativity, or in other way you can say it may be backed by inventive effort or creative effort. So what essentially these rights are? These rights are exclusive rights, which gives some sort of, you can say, a monopoly to the intellectual property holder to exploit his property by excluding others to enjoy the benefit of it. So there are various ways through which it could be exploited, like through licensing, through sale, so on and so forth. So what are the objectives of the protecting intellectual property? Why we protect it? So to protect innovation and creations and reward innovative and creative activity. So in a way, reward those who are involved in these activities. So as I mentioned before, these are exclusionary rights. They are negative in nature. What they ask for is no third person must use the rights which are reserved for the patent owner or the copyright owner or any IPR holder, unless and until he authorizes through licensing that the other person becomes entitled to use any of the rights which are vested in that very IP holder. So it excludes to enjoy the fruits of his labor by third parties. So this very concept of intellectual property has one more distinction, that it is an artificial creation of law to secure exclusive possession of intellectual property, meaning thereby it is the creation of a state to look into its economic progress, to look into its technological progress and the creative processes so that it may be put in motion. So it is governed by certain underlying policies. So what are those policies? The policy is first to secure for the public the benefits of intellectual property, and second to regulate and manage competition. So there are certain rights, along with that there are certain limits too, so that it will be balanced, and the ultimate goal, which may be scientific and technological progress, which may be economic progress, that must be promoted. So what is the stake of the countries, why they create these kind of statutory expressions to confer intellectual property? So to give first of all a statutory expression to the rights of creators and innovators, meaning thereby recognizing their stakes, recognizing their interests, because they are adding to the society something valuable. So to give statutory expression to the rights of creators and innovators in their creations and innovations, and it must be balanced against the public interest in accessing creation and innovation. And second one is to promote creativity and innovation in the society and the country, and therefore contributing to economic and social development. For example, there are so many innovations which are instrumental in solving the social problems, which are aligning to sometimes technological problems, sometimes some other problems. So if we are addressing making the life of the people more convenient, either through technology or any of the subject matters which are covered under intellectual property, it means we are addressing that very problem through these measures. So coming to the concept of intellectual property, it could be categorized in two groups. One is traditional classification and the other one is modern convention, like how we use now intellectual property term. So it is all based on the evolution of intellectual property. So intellectual property and industrial property were categorized differently in the traditional classification, and patent designs and trademarks were clubbed under industrial property, and only the copyright was conferred with the connotation of intellectual property. The reason behind that may be found that because patents, designs and trademarks, they are well aligned with the industrial activities in those times. That is why they were more close to industrial activities and they are conferred as industrial property. Copyright was more about the creativity, authorship, and these industries which we see today in the copyright, like music industry, like you can say, software industry, they were not, at that very moment existing. So that is why it was more or more a kind of creative work which was put under the domain of copyright. So this was the reason for this classification, but after the WIPO Convention 1967, all these activities were enlisted to be covered under intellectual property rather than industrial property. So modern convention is, in the due course of time, this distinction was diminished, and the modern convention is to use intellectual property to refer to both industrial and intellectual properties. What is the definition of IPR? Has not been established with a single definition. As in the case of human rights also, we don't find very concrete definition of human rights. So we do find some illustrations, some in a listing, where we can figure out that what is the subject matter of IP or subject matter of human rights. Likewise, you will see that most definitions simply list examples of intellectual property rights or the subject matter of those rights, and they are in inclusive form. In law, we usually do, or we usually use inclusive list rather than exclusive list to include future developments, to involve some sort of flexibility in that very approach. So we do have certain definitions which are inclusive in nature, which are including various subject matters of intellectual property rights. but they are not putting any limit that beyond that you cannot include any further intellectual property. It is all open. So rather than attempt to identify the essential attributes of intellectual property rights, concrete definitions are not given. So an example of this approach could be found, as I mentioned, Convention establishing WIPO, that is WIPO Convention 1967. So how it enlists various intellectual property rights? So that listing may include, here you may see, literary, artistic and scientific works, performances of performing artists, phonograms and broadcasts, inventions in all fields of human endeavor, scientific discoveries, industrial designs, trademarks, service marks and commercial names and designations, protection against unfair competition, and all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic fields. So this is an inclusive list, illustrative list, which may give you a kind of inference that what would be the subject matter that could be covered or protected under intellectual property. The second major enlisting, or you can say categorization, has been done in TRIPS agreement, where it categorically mentions 7 intellectual property rights and leaves a window for other intellectual property rights to be created or included. So for the purpose of the TRIPS agreement, intellectual property refers to all categories of intellectual property that are the subject of section 1 through 7 of part 2 of the TRIPS agreement, which includes number 1, copyright and related right, number 2, trademarks, number 3, geographical indications, number 4, industrial design, number 5, patents, number 6, integrated circuits, layout designs, and number 7, protection of undisclosed information, or in other words, we call it trade secrets. So to make it simple, you can easily figure out how this list works and what are the new intellectual property rights which are included in this very list. So we are very much aware of the copyright, trademark, industrial design and patents already. So the new additions are geographical indications, integrated circuit or layout designs, and protection of undisclosed information or trade secret. So these have been present in different forms earlier too, but now they are concretely defined under the TRIPS agreement. For example, geographical indication find its roots in trademarks under the appellation of origin, but some new attributes have been conferred and it has been concretized with the concept of geographical indication. So there is a one window, as I said, the window of sui generis system of protecting some items. So here you may see one of the examples you can see here in India, Protection of Plant Varieties and Farmers' Rights Act, which has been enacted by taking recourse of the sui generis system, that very window, where TRIPS allows members to either go for the patents or for a sui generis system or a combination of both. So new legislations are coming up for the protection of intellectual property rights through this route. So what is the current phenomenon of the intellectual property discourse? So intellectual property, the scope of intellectual property is expanding day by day. So the categorization which has been made in TRIPS agreement is being expanded to accommodate new subject matters which were at one time not a conventional subject matter of intellectual property. So you may see here that the canvas of IPR is expanding on an almost daily basis as new rights are created or existing rights are applied to fairly new subject matters. For example, genetic databases, semiconductor chips, human genes, so on and so forth. So such expansion implicates the most basic tenets of society such as information, scientific data, entertainment and technology. So this is a new challenge which is being posed by the, because of the importance of data which is increasingly becoming important on the one hand. On the other hand, the abundance of information, which sometimes have a very much commercial value, and because of that the line between invention and discovery sometimes becomes blurred, and it all depends upon the interpretation, how we interpret the respective law. So these are the new phenomenons in the domain of information technology, which are challenging the basic tenets of the intellectual property. So this is because of the nature, change in the nature of IP products, which were largely industrial at one time, and they are now transformed into informational goods. So this is all about the general concept of IP. In the next lecture, I will be taking up one by one, and I will start with the patents. So thank you.